Okay. I think we're streaming. Yes. Shannon, you could put us on the record.
Okay.
All right. This is the matter of Keene versus Chew Inc. So, counsel, if you could please state your appearances.
Brian Katinsky for Timothy Keene, the plaintiff.
Rick Girardet for defendant Chew Inc.
All right, gentlemen, I have read your filings, so you can be brief. Go ahead, Mr. Girardet.
Thanks, Judge. Judge, if you've read it, then I'll be brief once again. This is defendant's motion to strike. Under MRE 601, a witness must be competent. That is, they must have an obligation or a sense of obligation to testify truthfully, understandably. 602 requires that the witness have personal knowledge of the matter in which they're testifying about. Mr. Zabrowski, who has essentially been this Timothy Keene's father for the past 30 years, is not your typical disinterested witness. And it's important here, Judge, because Mr. Zabrowski admits in his deposition that he's not looking at this young man's feet at the time of the fall. So if he's not looking at his feet, it's my opinion that he does not have personal knowledge as required under MRE 602. Also,
well, he has personal knowledge of quite a bit, though, doesn't he?
Look at, absolutely, Judge. He could testify to.
He was there.
Yes.
He saw Timothy go down.
He could testify to
saw that the floor was wet.
Absolutely. He could testify to all that.
All right. I thought you were asking me to bar his testimony completely.
Maybe, well, that's my mistake, Judge. That's not in my intent at all. Look, he was there. He's a fact witness. He can testify to everything else other than what caused the fall, because he makes an assumption that he slipped. And I try to ask him, what his knowledge is, what personal knowledge he has. And the question specifically that I asked, because he's right in front of you, you're not looking at his feet. Answer, right. So he doesn't have personal knowledge, but then he still claims that he slipped. And then, so I ask him further, did you actually see a foot slip? Answer, I seen his whole body go down. Question, right. That's not my question. You didn't actually see his foot slip. Answer, questions like this, I'm not going to answer. Then he goes on. Then I go on, because you're not looking at his feet. Answer, no, because it's intimidating what you're doing. Question, so you're refusing to answer? Answer, that's right. So I'm trying to find the basis of his personal knowledge that he makes this assumption or conclusion that he slipped. I'm trying to find out what that personal basis is. And
where did he say he slipped?
Hello.
I think it was earlier in his deposition. He says he didn't trip, he fell. The water was right there. He hit the water and he went down. Question, but once again, you weren't looking at his feet. Answer, true. Answer, I'm looking at him like I'm looking at you. I'm looking at his whole body. Question, right. But if you're not looking at his body, if you're looking at his body, you're not looking at his feet, how do you know he didn't trip as opposed to water? Answer, he fell. Question, that's your assumption. That's what happened. So, and there's another part of the deposition where he claims he slipped, because that's the entire basis of this case, because he's the only witness. So what we have here, Judge, is a situation where I'm trying to find out exactly how or why it is he thinks he slipped. Well, I know that there's water on the floor, and he testified that he stepped in it. That's all fine. But if you're not looking at his feet, how do you know he slipped as opposed to tripping or a seizure, which this young man has difficulties with, and some other issues, anything else that could cause you to fall? So I'm entitled to ask those questions, and I do, and he essentially just cuts me off, and he's just not going to answer those questions. And I know this is a drastic type relief here, but I don't know anything else that works, because I was entitled to that answer at that deposition. That's a perfectly acceptable a question, Judge, when you're inquiring as to someone's personal knowledge. How do you know what it is you claim to know? And if we have a trial judge and I ask those questions and he says, well, I'm not looking at his feet, and he testifies otherwise on direct that he slips. And then I say, well, how is it that you know you slipped if you weren't looking at his feet? And he says, oh, I'm not going to answer these questions. And I'm sure the court's going to say, witness, you need to answer that question. And
Doesn't that address the issue? I mean, we're not talking about a party that's refusing to answer questions where I can have, there's some strict remedies for a party that doesn't. We're talking about a witness, and you want me to bar him from saying what?
from testifying how it is he thinks he slipped and fell. I mean, he could testify he got in the water, and he could, but why is he able to testify that he slipped if he admitted he's not looking at his feet and he refuses to answer follow-up questions?
That sounds to me like cross-examination and argument to the jury, not a reason to bar a witness from whatever it is he's going to say. If he testifies differently from his deposition, you've got his deposition to cross-examine him on.
Well, but if we think this through, Judge, I mean, that's the whole purpose of discovery, is to find out what he's going to say at the time of trial. I don't know what he's going to say because he refused to answer the question.
Well, you know what he's going to say about were you looking at his feet?
Well, that part?
You know
Sure.
what he's, I guess, I don't see how I enter any kind of a restrictive order at this point. I mean, if something outlandish happens when he's on the stand, I can certainly deal with that at the time. And you can make an objection and we can take the jury out and I can explore it. But to ahead of time say, I'm not going to allow him to testify about whatever it is the restriction is, I'm hard pressed to do that.
So the court is going to allow then, by inference then, counsel for plaintiff to elicit testimony. Once again, I know he's not technically the plaintiff, but he's been his stepfather or de facto stepfather for 30 years.
And you can certainly argue that kind of bias to the jury as to whether or not they should believe this witness.
Sure. So Judge, so what happens if we get to trial and now he's testifying as to hypothetically some other reasons why he thinks he slipped when he refused to answer the questions during his deposition? I mean, it's trial by ambush.
Well, if in fact we get some outlandish testimony that's inconsistent with what he said, I can certainly deal with it at the time, but I'm not going to speculate today as to what outlandish testimony might cause me to invoke a bar against him answering a certain question. I guess if he said that an alien ray struck his feet and knocked him down, I can see that I would definitely probably intervene, although I don't know that I'd have to, because any reasonable minded jury is going to realize that that's preposterous on its face.
Right, Judge. I'm just in a position here, and I'm not arguing. I'm just indicating that this is going to be a very sympathetic plaintiff, and it's going to be a situation where the jury is going to have every reason to do whatever they think is right, notwithstanding the law that's going to be read to them from the bench. And I have an obligation to my client to make sure that we have a fair trial here. And if I take a witness deposition, Judge, this is the only witness to the fault. This is the only person who's given every testimony that there's a slip.
The plaintiff here is nonverbal, or
Correct.
Okay.
Yes, Judge. Yes.
So he's the only one who actually saw the plaintiff go down.
That's correct.
There are other witnesses as to the condition of the floor, condition of the restaurant, etc.
Yes.
Yes, Judge, I don't have any problems if his testimony is limited to his deposition. And if he's gonna, I mean, this is fine. If this is what he's gonna testify to, I wasn't looking at his feet. I saw him fall. I don't know how, because I'm not gonna answer those questions. That's fine. But now if he shows up and now all of a sudden he's had a year to think about it and come up with all kinds of reasons why he thinks he slipped. I mean, they had every opportunity, Judge, at his deposition Counsel for plaintiff was there. He heard this testimony. He could have asked him anything he wanted to at the time. I just don't want to get blindsided at trial with some other evidence when he refused to provide it.
All right, I'm going to deny your motion. You may certainly renew it or make an oral motion at trial if there's a basis for doing so. I'll certainly consider that at the time. If we need to, we'll take the jury out. But I'm going to deny your motion.
Your Honor,
Thank you, Your Honor.
Your Honor, if I may, I mean, I was very surprised to get a motion like this from such an experienced attorney like Mr. Girodat without any case law. I've never heard of this. Now I don't even understand the motion, because the motion was to strike all testimony, and now he's saying, well, he's got to stick by his deposition. And Mr. Girodat knows. These are typical trial issues. Well, you said this at your deposition, and you're saying this now and you won't answer. There's no basis for this motion. He's wasted my time. He's wasted the court's time. And frankly, he should know better. I don't usually ask for costs. I'm asking for cost here to be paid to the Bar Association just to discourage these types of frivolous motions, which is what this is.
I'm not going to award costs.
Okay, Your Honor. I should
So as long as I have you here, let's talk about trial. Do you have a trial date currently?
I don't think so, Judge.
Your Honor, I should tell you that we are facilitating this case with Mr. Best in about just a few weeks. And that's on May 20th. And perhaps we can set a settlement conference after May 20th if that doesn't settle the case.
All right. I don't know when we're going to be able to start doing jury trials again. We were moving forward towards some limited ability to do that. And then when we moved back to phase one, all of that just disappeared. We're still at phase one as far as I know. I haven't seen any official directive that we've moved to phase two. And normal jury trials is phase four. So we got a ways to go. Our numbers are looking good, but I'm not rescheduling jury trials currently. I'm scheduling pretrials, and at the pretrials, if we're far enough along that I can schedule trials, I'll start scheduling them. But for now, I don't think you need to worry about a trial anytime soon. So hopefully your facilitation is successful. If not, I'm certainly willing to engage in a settlement conference. Just let us know.
Okay, so just want to leave that open for now. So there's
no. Is there anything on the? Well, let me pull up your case. Hold on, I'll answer that for you.
Judge, we were going to take care of the stay issue as well, assuming there was one entered.
Yeah, if there was a stay, I will certainly be willing to enter an order lifting it.
Okay, I know you've been on the record. I don't remember if there was an order, Rick, but we'll check that out. I just want to make sure the record's clear.
That's fine.
All right, well, hold on a second. Let me, we've got a pretrial scheduled for July 23rd.
Okay, very good.
So let's just keep that on the calendar. There is a trial set for August 23rd. That's highly unlikely. I'll keep it there for what it's worth, rather than directing my staff to remove it now. I mean, I guess it's conceivable that enough people get vaccinated that we move right on to phase four, and we'll just keep you there. But you can let me know at the pretrial whether or not a settlement conference, whether you think a settlement conference would be helpful. Okay, and we'll figure out then what would be a realistic trial date.
And Your Honor, what time is that on July 23rd, just so I can mark it down?
11 a.m.
Okay, very good. Rick, I'll see you in a
few. You're certainly welcome to Zoom. I'm going to allow Zooming to pretrials forever and Zooming to motions forever. I think it just makes good sense. If you want to come and the courthouse is open, you're certainly welcome to, but I'm leaving that door wide open.
Yeah, the Court of Appeals, I just got a notice from them that they're starting to explore that too. So it's interesting how this has changed everything to a certain extent.
Yeah, there are aspects of it that I think have been very good, even though it's been a tough year, that hopefully will begin to streamline some things. But it's nice to have the option of doing something other than live. And we probably wouldn't be anywhere close to where we are now if we hadn't gone through the past year. So
True.
I see that as a positive. All right, anything else this morning, gentlemen?
No, gentlemen, have a good day. Thank you, Your Honor.
You too.
Thanks, Brian.
Take care.
So did you have any problems with one leg feeling longer than the other at all?
No, in fact, surgeon told me that I was a little bit off before and he fixed it.
Really?
Yeah.
See, that's always the trouble they have, because you want to have that good fit, but it can't be too tight. And sometimes when you do that, they're always gonna sacrifice the length for the good fit, so you're not dislocating and whatnot. So it's always a kind of a balancing act.
Yeah, no, so far so good. Everything's
good.
doing well. And the other hip, which is bad, is not hurting. So,
Well, you know what? Maybe when you level off a little bit, you're not favoring that one, and who knows?
I'm sure I was putting a lot of extra weight on the other one.
Yep.
So
Well, good.
I'm not going to see you back over there anytime soon.
I have an ankle that needs to be replaced,
Oh, wow.
and I'm trying to hold it off as long as I can. And I think I'm trying to convince Tian just to get in there and clean it up as best he can and go from there. But he says, if I'm going in, you're getting a whole new one. But I
Is this something you heard a lot while you were playing?
heard it in college, and it's been bad ever since. But I get around.
All right. Well, good to see you, Rick.
Good
Take
seeing
care.
you too. Thanks, you guys. Good luck to you.
Yeah, thank you.
Shannon, keep driving.
Okay.
Right.
Hawk versus Douglas and Loring. Counsel, could you each identify yourselves?
Good morning, Your Honor. Brian Muad appearing on behalf of the plaintiff Dina Hawk.
Good morning, Your Honor. Max McHugh appearing on behalf of defendant Loring.
Good morning, Your Honor. Stephanie Scipione appearing on behalf of defendant Douglas.
All right, and I believe this is defendant Loring's motion to dismiss for failure to permit discovery.
Correct.
If there was a response, I haven't seen it. Was a response filed?
Your Honor, on behalf of plaintiff, I don't believe a response was filed because the remaining issue in the case for the discovery is the authorizations that I believe defendant Mr. McHugh doesn't have. And up to yesterday, we were trying to get the authorizations from the client, but we're having some difficulty communicating with her by email and by phone. Just to give the court a little bit of history, apparently the dates have been extended on this file for discovery and adjournments have been effectuated recently. I think this week we signed a stip. I'm not trying to excuse myself, Your Honor. I'm not trying to in any way, shape, or form, but I worked with Mr. McHugh's associate attorney to get him the discovery for the interrogatories. The client has produced herself for a deposition. I believe the only issue that Mr. McHugh has this morning, I could be wrong, is the authorizations. And they have, of course, they have every right to those authorizations. I think we were trying to, my secretary was working diligently by email, by phone to get a hold of the client, to get her to sign them. And that's, I believe, is the sticking point of, it's my understanding anyway.
So the client is not responding?
Well, she sat for a deposition and she responded to interrogatories. The only thing remaining issue is the authorizations. I think if court were to put maybe like a sunset provision in there, that might get her attention. I don't know. I'm just guessing. She's missing in action right now as of the last 10 days when we tried to get a hold of her to get us a copy of the authorizations. But up to that point, she cooperated.
Why weren't the authorizations presented to her for signature at the deposition?
You know what, Your Honor? I think that's a figment of COVID. I think you're right. When we used to all be together at the deposition, it would be, we sit across the table from each other. I sit with my client, defense counsel sits across the table. At the end of the dep, defense counsel presents them. But unfortunately, we don't have that luxury. And no, I guess what could have been had at that point is, and we haven't gotten to that point where it's a work in progress, perhaps maybe under the circumstances. I could have requested of defense counsel, well, you got her here, and I didn't take the initiative, so I blame myself on that. Email them to my office. I will then email them to her somehow, and then we could get her to sign them. But I did not take that initiative at the deposition.
So currently we don't, I mean, when was the deposition?
I believe, Max, correct me if I'm wrong, was it a couple months ago?
I think it says April 1st.
Thank you. Thank you.
So sometime after the deposition was taken, something's happened to her. She's not responding to email. She's not answering the phone. And you really have no idea or explanation what that might be. I mean, is she in a hospital ward somewhere hooked up to a ventilator because she's struggling with COVID? I mean, I'm sympathetic to that kind of an issue, but we really don't know what it is. We just know that you can't get a hold of her. Everybody agrees this is a reasonable request.
Oh, absolutely. Yes.
There's no reason that we have to believe that she wouldn't sign it if she were presented to it.
Correct.
But you can't get a hold of her.
We can't get a hold of her. Correct, Your Honor. I'm going to make a policy in this office. You brought something to my attention. While we got these plaintiffs if they haven't signed the authorizations, I don't care, even with COVID, just email them to me. I'll find a way to get them to my clients somehow, even though my client's sitting in Jackson County or in Kent County, and I'm down here in Macomb County. But that's something worth, recognizable I should do. I should implement. Get them while they're there. Get them while it's hot, type of situation.
So what I'm thinking about was your suggestion that we give her a drop dead date. You either sign them by this date, or the problem with that is if you can't communicate a drop dead date to her, it doesn't have much effect. Well, let me hear from Mr. McHugh.
Your Honor, we've been waiting for these signed authorizations since December 2020, when we sent initial discovery and authorization to plaintiff. We did enter a STIP order on January 4th, compelling initial disclosures and authorizations. When those weren't at first received, we did file a motion to dismiss. The initial disclosures were received, so we did cancel that motion to dismiss. But we still have not received any authorizations on this. Another stipulated order compelling the authorizations was entered March 26th, and they were due by March 29th. We still have no authorizations to file.
We did this week, Your Honor, get the dates extended. I don't know necessarily at this point. Now, the dates were extended probably because of dilatoriness on our part. However, I don't believe it's intentional. But this week we did sign, the court was kind enough to sign an order to extend all the dates out. I don't see the prejudice on Mr. McHugh's part, but gosh darn it, he's definitely entitled to them, Your Honor. Absolutely. I can't make waves with him in that regard.
So, is it Scipione?
Yes, sir.
Did you have anything to weigh in on this?
I know that we more recently have submitted through record ordering company for a few select records. So the process is underway, but it's newer, just in the past like few weeks. So we haven't brushed up against a problem with it yet, as I'm not sure what stage they're at in obtaining that. So we anticipate the same issue, and I've been aware of, from deposition, I've been aware of the issue getting the signatures. So we have the same concern.
All right, well, here's what I'm going to do. If these authorizations are not signed and returned to Mr. McHugh within 14 days, I am going to dismiss the claims against Defendant Loring, unless Mr. Muwad, you come forward with information that shows that your client was incapacitated. I want to leave the door open just in case there's something weird going on here that we just simply don't know about. I don't want to punish her if she truly is incapacitated. But absent a showing that she was incapacitated from signing and producing these releases, I'm going to dismiss the case. So 14 days from today's date. And Mr. McHugh, you'll prepare that order?
Yes.
All right. Thank you, folks.
Your
Thank
Honor,
you, Your
thank
Honor.
you for everything, and everyone, thanks for understanding. I appreciate all the latitude this court and everyone has afforded me. You guys could have been a lot worse at the hearing and wanted a pound of flesh and didn't, so I appreciate everything. Thank you.
Thanks, Brian.
Thank you, Max.
All right. Have
Thank you,
a good day, everyone.
You too, Your Honor. Have a good week.
Thank you, Your Honor.